Good evening. Would you stand with me for the invocation and pledge of allegiance? Diane?
Father, truly thank you so much for this day. Thank you for this occasion. Father, we thank you for each council person, Lord Jesus, that you have placed in position. We're so grateful, Father, that we get to come together this way. You are the one who ordained government. So we thank you for this privilege, God. We ask that you will bless each one. Father, give them wisdom and discernment as they discuss the issues of the day. We will forever give you the glory and the thanks that you deserve. I ask these things in Jesus' name. Amen.
Councilwoman Benton, if you would, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to call to order this regular session of the Vienna City Council for June the 9th, 2022. Let the record reflect that I've taken roll, that all members of council are present this evening. Having a quorum, we will proceed. We have 6 people that have signed up to speak on the public forum this evening. And so I would just like to remind you all that you are allowed 5 minutes. And we will start this evening with Nicole Aguilar.
Situated under camera. Can you see it up there? Okay. Can you hear me okay? All right. Hi, my name is Nicole Aguilar. I proposed amending the Livestock Ordinance last council meeting to allow no less than 2 hens. Today, I wanted to present possible suitable chicken coops that can give everyone a better idea of what urban chicken keeping would or could look like. The goal is to have a coop that is an appropriate size for your backyard, while always keeping the number of hens you'll have in mind and while keeping your yard looking presentable, neat, and tidy. You won't need something huge for just 2 or 3 hens, but you may want to look into larger options if you have 4 to 8 hens. A person serious about keeping hens, like with any pet, should do their research before jumping into it and consider things such as winterizing, which is a must in our area. Also keep in mind that depending on how handy a person is with building things, many of these examples can be made at a lower cost. First, I'll present some lower cost options that can be purchased from popular sites and stores. These first 2 examples are suitable for a small number of hens. The top one is from Home Depot for around $300, and the bottom one is from Amazon for $200. Okay. All right. The top coop here is from Chewy.com for $218, and the bottom coop is from Lowe's for $260. All of these coops include roosting boxes and ramps. Roosting boxes are necessary for egg-laying hens, and FYI, hens love ramps. There are many options without these features, but they would not be suitable for egg-laying hens. Go ahead. All right, and this next one was shared on Facebook from Chad Emmerich. I'm not sure where it's from, but it's very cute. It has all the features needed, including a small area at the top to grow vegetable greens to feed your hen. Okay, you might just have to position it on the top one and then move it up. Okay. These next examples are DIYs made from common yard items you may already have. For anyone who's had children, you'll recognize these. The top picture is of a child's playhouse that has been converted into a chicken coop. Depending on the number of hens you'd have, you may not need the side addition, but you'll notice they've added a ramp and roosting boxes in the windows. The bottom one is made from an old swing set frame. It's wrapped with chicken wire, and half has roofing material installed to provide shade. I would recommend making or buying roosting boxes with a ramp to add to this. Okay, turn that one. This last example is both a DIY and a purchased product. This size shed would be more suitable for those who have a larger number of hens. It's a resin shed with some inside additions to make it into a coop. This particular shed can be found for around $1,000 at Lowe's, but smaller versions are cheaper. I hope these examples show that urban chicken keeping can be done without a ton of expense while maintaining a clean and beautiful yard. I also understand that there are many pressing issues that need addressed and are arguably more important than my request for amending the livestock ordinance. But I, along with many other people, will hope that this is not put on the back burner and is put on the agenda sooner rather than later. And that's it. Thank you for your time. I don't know if you want to see these up close or anything at any other time. I can give them to you just to look at. Thank you. I don't need them back.
Tamara Rhodes.
Good evening, I'm Tamara Rhodes. I just have a few things. The first is about the 12th Street presentation I did last week, or last council meeting. During that, I had said that I would like to see that added to the agenda so that there could be some answers and some explanations as to the land sale contract with Ace Foundation. So I was pretty dismayed to see the agenda and to see that there was no updates on Spencer or on 12th Street on that agenda. The other thing I wanted to say, now that we know that there is a kayak ramp dock project that has a letter of permission from the Corps of Engineers, although that is not a final permit, I think that that's something that the council and the public needs to hear the council discuss. I think it's great that that's in the process. I think there's nothing better than to have river access, and I think that's a great location because the water is not open water. You have New Island there sheltering against the riverbank, so the current and the wake and everything will be easier for inexperienced kayakers like me. Experienced kayakers could probably handle the whole thing, but I'm not that way. The second thing I wanted to talk about was basically the car wash on Grand Central Avenue. Very disheartened when I saw them tearing down the building. My thought was, and everybody else that I know, wow, there's something great that's going to go in here, and this is going to be a perfect opportunity for something. And myself, as well as everyone I know, is like, oh my lands, what is this, for lack of a better term, monstrosity that has been placed in the middle of the business district of Vienna? I'm not going to repeat what some of the people have said about that, but it really, as you said, Mayor Rapp, this is a pride of the valley. To me, that car wash takes that down about 10 steps. It's not consistent with the other architectural details in the neighborhood. It just stands out like a sore thumb. Plus the noise level for the neighbors, I think, is going to be a factor. I'm not going to get into that, but when I was looking that up, when I felt like that, I wanted to see how those decisions are made. So I went to the ordinances. I was looking for the Planning Commission ordinances. And what I found was that those ordinances all cross-reference the West Virginia Code 824. So when you go to the code, all those sections under 824 were repealed in 2004. So there's nothing else on there. And so like the duties and powers under the Planning Commission, there's nothing to back that up because there is no code 824 anymore. So I just wanted to bring that to your attention because I don't know if someone needs to correct that. I don't know if it's okay to be it like it is. I'm not a legal person. The other thing I would like to suggest, we've been talking about the parks a lot. We have a lot of wonderful things in our parks. However, a couple years ago, I was going to start walking. And I could not find a map of Vienna and where all the trails or walking paths were. And I called the city building, and they said, no, they didn't have anything like that, and there's nothing on the website. And still today there isn't. And after that presentation from Jim Christie and the master plan, I think it would be a good idea, even though we have things in the works and some of that may change, is to develop a map of the park areas in Vienna. And it doesn't have to be extreme. It can be very simple with just different things highlighted. Like number 1, and a legend that says, okay, this is a walking trail. If someone is coming in from out of town and they're staying, say, down by Lowe's, whichever hotel that is, and say they have a dog, how do they find the dog parks? You can't. There's nothing that says where they are. Where do you, if you're a tennis player and you're here from out of town or even new to town, where do you find play tennis or pickleball? Or if you want to play basketball, your kids want to go to the basketball thing and play. There's nothing that says. I just think it would be a wonderful opportunity to draw attention to the parks and to highlight all the activities and all the things that Vienna has to offer for recreation and for exercise and for health. That's all I have to say. Thank you.
Next is Liz Ford.
Good evening. Thank you for the opportunity to be here, and also for your commitment to the community. I wanted to take a minute to let you know that I'm with the ARC of the Mid-Ohio Valley. I'm the executive director, and our offices are actually located at 1917 Dudley Avenue, but of course we serve the entire Mid-Ohio Valley. And we are impacted by some of the unintended consequences of having 24% of the recovery facilities located in this area. And so we respect and appreciate that that's a problem. And by we, I'd like to let you know that I've been working with Westbrook Health Services, SW Resources, Wood County Society, Strive Advocacy, and other providers of disability services in our community. And while we respect that there's a challenge, we're concerned both with the ordinance being proposed in Parkersburg and the potential ordinance here, because we want it to be successful and achieve the goals that you desire. And based on well-established law, West Virginia Code, which, can I, pass this along? Regarding permit use for group residential facilities. Also, Disability Rights of Pennsylvania did a pretty in-depth study and put together some great information that applies nationwide regarding discriminatory zoning and the Fair Housing Act. The purpose of the act is to prohibit practices that restrict the choices of people with disabilities to live where they want to live, or that discourage or obstruct those choices in a community, neighborhood, or development. Given the broad remedial goals of the FHAA, courts have held that its provisions should be broadly construed. Courts have also rejected constitutional challenges to the application of the FHAA to local zoning laws and decision. Persons who are recovering from substance abuse are also considered to have a disability under the FHAA. Once again, we recognize there's a problem. We deal with it. We appreciate that things need to be addressed. We just don't want you to put something into place that wouldn't stand up to established law. One of the other things in some information here is that the FHAA prohibits a broad range of discriminatory activities, and under the law, to discriminate in the sale or rental or to otherwise make unavailable or deny a dwelling to any buyer, to discriminate against any person in the terms, conditions, or privileges, to refuse to permit at the expense of the person with the handicap reasonable modifications. All of these things go against established law. And then zoning and the Fair Housing Act, there's a provision on intentional discrimination where you don't have to be aware that you're discriminating, but it could still be considered intentional. And then I also brought information, I won't read the whole thing because I know that would be boring, from the Department of Housing and Urban Development and the U.S. Department of Justice Civil Rights Division that spells out the same information, basically that you can't conduct an ordinance against a specific group of people that are protected, and people with disabilities are protected in addition to people or to discriminating on the basis of race, color, national origin, religion, or familial status. So we just want to invite you to re-examine what your intentions are and maybe look at rewording. And then we also ask that in any ordinance that you choose to propose, that you recognize what we call people first language, where you say a person with a disability and use the proper terminology when you're referring to someone with a disability in the community. And I have some information about that as well. And finally, I just want to let you know that in Petal, Mississippi, Tays Valley, and Clarksburg, similar ordinances were overturned because they violate the Fair Housing Act and West Virginia Code. And so, once again, just to sum up, as we recognize that there's a problem and would like to be part of the solution, we just want to be sure it's done in the proper way and that things don't have to be redone because they're not worded correctly. And I thank you for your time.
Kelly Craft.
Hi, my name is Kelly Craft, and talking after the people before me, this seems kind of selfish, but I have been struggling with this problem for quite a long time. We've lived at our residence for 37 years, and it has become an issue, a weekly issue. We live at the corner of 57th and 3rd Avenue. And we get a lot of the cross traffic from Greenmont School when they let out. We had a wooden fence when we first bought the house, and someone hit it, tore it down into our yard because it's not a full-size yard. We put cement planters out there. We put 4 of them along the front of our yard there, and it got to the point where we were spending probably $200 every 3 months to replace those planters. So we went to plastic planters. Well, we're down to 2, and my husband refuses to buy any more. So we need a solution to keep people out of our yard. These pictures are just from the last 3 months. I know this isn't good, but I can let you guys see them later. My husband was off work for a injury to his shoulder, and he saw something big in our yard, and he thought, oh, wow, a big dog or something. He went to the window. A car with all 4 tires were in the middle of our yard, going around a car that was parked to pick up their child. 3 cars followed that car and exited out of our driveway. And I've called The principal, I've went through 2 principals because they've changed, and they have talked till they're blue in the face to the parents, and they cannot get any results from the parents. My suggestion, and I'll let you guys see these pictures, you're not going to be able to see them well, but my suggestion, this is my little map, if we would make 3rd Avenue from 57th to 58th, where Greenmont is, one way, to where they cannot come this way and turn into our yard, because that's the issue, is when they're trying to make that turn, that's when they're going into our yard. If we could possibly make that a one-way, that would eliminate, I think, that issue. Or if we could put a curb there, because there are no curbs on that road at all. I would even give you some of my property to put a sidewalk, if that's a possibility, but we just need something done. I'm at my wit's end, because these pictures, I mean, it was a rivet where it was muddy. It was up to my ankle, where I actually put my foot in the tire track. So I would just like this to be resolved some way. Thanks.
Hey, Kelly, before you leave, the pictures that you have there, do you have a picture of down the street towards the fence?
The fence that is behind the,
When you're looking at the front of your house, to the right,
no,
there is a chain link fence that is right there.
right, and it's right almost on the road. That's Dan Lyons' property.
Yes.
Yes.
Okay. So let me just explain something, because she's up there. All right. The corner of the fence, according to us, is the property line. All right. Now, I will have that surveyed if you think that that is something that we need to establish. All right. Because that corner of that fence is probably 3 foot in on the grass. All right.
I wouldn't even say that much.
I'm guessing.
Yeah.
All right. But at any rate, if you all would like me to get that surveyed so we can determine where the boundary is, but when you look at the maps that we have, it appears like that corner of that fence is the corner marker of your front yard.
Right.
Okay. So, I mean, until we determine where that actual, boundary is, it's going to be really difficult to determine if there's an issue. Okay. But it's very expensive to get it surveyed. When I say very expensive, I'm going to guess it would cost somewhere between $500 and $700 to get that property surveyed. But if that's what you all would like done, then I will certainly get that done. Okay. So Kelly, we'll get back to you and decide what to do to try to give you some peace of mind. All right.
Yeah.
Okay. Deborah Jenkins.
Good evening. I'm here just because on Memorial Weekend, we had rented the community building here in Vienna, and for my husband's family reunion, and we were parked along 34th Street, and we arrived approximately 12:15. That's about the time we usually start our family reunion, and between that time and 1:15, 2 cars were broken into. And both vehicles were off camera, according to Vienna police. A wallet was stolen out of the one vehicle. Now, nothing was stolen out of my vehicle, but we did not park close to the building because we have elderly that are attending the family reunion, and I am able-bodied to walk to there. So we have now discovered, after talking to the police, that the cameras that are on that building do not collect any information from the corner parking spot that is facing Jackson Middle School all the way across 34th Street to the end. So it's the entrance and the exit to that community building, which means that if you have a child who would go around that building for a soda, which is where that soda machine is located, that child could come up missing. Not just my car window being broken into, which is cost me $400, which is what they've gotten away with, but we could be looking at a bigger issue here in our parks. I mean, we've seen it all in the news lately. I mean, there were 75 people in that building eating at that time, and someone come in and said vehicles' windows have been smashed. And that's a parking lot for that whole park, the dog park, the playground, everything back through there. And it just, to me, is a very big issue that you don't even feel safe in a, my husband grew up here, and he says he's not going back unless there's something done. There's more cameras put up, because the city police officer did tell us that he could see the tag on the dumpster, which was the least of our concerns at that point. It was our vehicles. Thank you.
Doug Hess.
Hi, I'm Doug Hess, and I grew up in this community. I also worked with Ms. Ford at the ARC, and I just want to echo some of the comments. I used to work on the radio for many years and came to this council and know that you have lots of rules and regulations and laws that you have to follow, and your job is to legislate and protect its citizens. But there's also rules and regulations you have to follow that can't violate what's already in place and go against state codes and things. And so I also agree and understand that, there's a certain group that maybe you're trying to target, or a certain thing you're trying to fix by looking at an ordinance similar to Parkersburg. But if it's going to violate a law, and the housing law, one of the first goals of the Fair Housing Act says to not discriminate, including group homes or against certain individuals, you can't divide that out and go, well, we don't mean this group. We only want this group of the list of people that have disabilities. You can't do that. Similar to, you can't zone and say you can build a store here, but you can't build a store in a residential area. Everything has to work well and be equal to everyone. And we're just simply looking for equal opportunity for everyone. And again, we understand what you're trying to do, but would encourage you to make sure that the language is correct and that you're following what the federal laws are, so that you don't later have to say, well, this was a good idea, but it didn't really fix what we were trying to fix. So I just wanted to echo many of those things. And I understand it's very difficult to sit behind there and hear things, whether it's raising, chickens in the city and people driving through yards. So I know you have many things you have to work on, but I just want to encourage you to look really closely at this before you put an ordinance in place about substance use disorder, because while it may, what you're looking for may fit in that broad category, as I said, you can't pick that part out and ignore everyone else in there. So just wanted to, and the other thing that wasn't brought up is, there isn't any way of saying, you don't have people walking around the street saying, well, this person has a disability. There's no rule or regulation that says you have to announce that to anybody. So if you were to put in place people who were doing a certain thing, I don't believe there's a rule or regulation that says you have to announce you're in recovery, or you have to announce what you're doing. So if a group of people just doing what everyone else does and doesn't disclose whatever their thing is, that they want to buy a house or do whatever, I don't believe you can put regulations against that, and you wouldn't know that they were violating it anyway, because you can't say everyone with this now has to report to the city. You fit in that category. So I think that's just something else to look at while you're looking at these ordinances. Thank you very much.
The minutes from the May 26, 2022 council meeting have been printed, posted, and circulated. Are there any corrections to the minutes? If there are no objections, then the minutes will stand approved as posted. Report of the treasurer, Councilman Leach.
Reconciliation of funds for City of Vienna for June 3rd, 2022, been reviewed. The accounts appear in order, and the city is certainly financially sound.
All right, thank you. We have no unfinished business this evening, so we'll move right in to our new business. The first item on our agenda this evening is an ordinance regulating group residential homes. Mr. Skogstad, I know that you've drafted this ordinance. The item number 2, down under 1326.06, the number of residents, including staff, shall not exceed 12 or one person per 200 square feet of interior living space, whichever is less. I want to make sure that you all have that 200 square feet. Okay? All right? This ordinance when the state legislature decided that they would set up some rules for these situations, there was supposed to be oversight by the DHHR, the Department of Health and Human Resources. And unfortunately, they farmed that responsibility out to another agency. And because of that not clarity in the way these things are being handled, the certifications that are required are not, in my opinion, being followed. And so when you look at these definitions that are in this ordinance, it is simply a protection that says we're not going to be flooded with all of these structures that, in my opinion, do not conform to the neighborhoods that we all live in. And so in the circumstances that we've dealt with in the last year to year and a half, there have been instances of multiple individuals living in a single family dwelling, which was designed to handle a family. And unfortunately, these are not the way that things are being handled. And so in order to protect our neighborhoods, this is a proposed ordinance. The ordinance that we have in effect now will expire July the 1st. And so with the terms that are in this, this ordinance would pick up where that one, if it is passed on second reading by council, and would define some of the issues that we have encountered. And so that's the purpose of this ordinance. It's not meant to discriminate against anyone, but it does protect the neighborhoods to some degree with the regulations that are in there. Mr. Skogstad, have I said anything that I misspoke, sir?
I don't think so. I mean, I think if you actually read the content in the ordinance, or the proposed ordinance, it's not targeting a group. Now, it does incorporate, and I certainly understand the lady who was talking about the definitions and so forth, but the definition that is incorporated in this ordinance actually, you know, whether it's the best phrasing of it, it's just the phrasing that's from the municipal or from West Virginia State Code. It doesn't target people. It's attempting to balance structures and how they're occupied in neighborhoods that were originally not zoned for those, or for the, it's trying to balance the way structures are used in neighborhoods that were not zoned in the way that these structures are being used, because these structures have been given an exemption under state code that some of our, I guess, ordinances, zoning regulations, and so forth don't apply. So I don't think anybody wants to keep individuals from living in group homes out of their neighborhoods. But you've also have a neighborhood where you have historically single family dwellings have been occupied for years And granted, what we think of as a family has changed, but they've been occupied for years, and all of our ordinances and our zoning and how we deal with those was to some degree preempted by the passing of the legislature and the way they pass their statutes. So I don't think the intent is to target people, but it is to try to have these, what are essentially businesses, operate in residential neighborhoods with at least some degree of oversight, considering the safety of the individuals that are going to be living there. Some of these places, you could have folks that live there for years. Some places, the business that's in there could be transient in nature. One of the things that we're looking here as far as the number of residents is to just put a square footage requirement in, which is what we have in our tiny houses, our small houses or tiny house ordinance. The distance of these, not allowing advertising, just asking that all of the structures be kept in compliance with building and fire safety regulations, that if they're required to be licensed, that they're licensed. If they have parking, that they just be in compliance with the ordinances that we have for parking, and so on and so forth. So I don't think the intent of this ordinance, at least certainly not as I've contemplated it, and granted, this is essentially mirrors the ordinance that Parkersburg has passed. But I don't think the intent, that Parkersburg has not passed, but Parkersburg is addressing. I don't think the intent of this is to target anybody. But there is a balancing act, and the balance has been thrown a little bit out of whack, in that you can own a building and be a landlord, as I said a long time ago when we were talking about the moratorium, is you can be a landlord and have certain restrictions of every other type of structure in a neighborhood except for a group home type structure, or you can have a group home type structure where some of the regulations that we have don't apply. So it's tough. So I don't think it's to target. I don't think it's to target people. I think it's that there's a situation that's been thrusted upon us, and council, I think, is trying to manage that situation, and there just aren't very many tools to do it and to remain fair to everybody.
So I'll read the ordinance by title. You all have all of the different definitions in front of you. It's an ordinance regulating group residential homes. Be it ordained by the Council of the City of Vienna that Article 1326 of the codified ordinances of the city is hereby enacting regulations for group residential homes. 1326, 1326.01, 1326.02, 1326.03, 1326.04, 1326.05, 1326.06, 1326.07, and 1326.08. I'll entertain a motion for the approval on first reading of the ordinance regulating group residential homes.
So moved.
Second.
It's been moved and seconded that we approve on first reading the ordinance regulating group residential homes. Is there any discussion?
I have some questions about this. I'm going to start with the definitions first. So definition, the purpose of this article, group residential homes shall mean a building owned, leased, or occupied by developmentally disabled or behaviorally disabled persons for a purpose of establishing a personal residence. We have not, or maybe it's here and I don't see it, but can you tell me the definition of what a developmentally disabled or behaviorally disabled person would be? Because it's not defined in this ordinance.
Well, I can tell you that the definition comes from West Virginia Code 2717-1, paragraph D, which reads, group residential home means a building owned or leased by developmentally disabled or behaviorally disabled persons for purposes of establishing a personal residence. And that is the definition that the state has adopted.
Well, I'm asking that because when you say developmentally disabled, that can include a lot of different people, and I think there's the law of unintended consequences here. For example, people who may fall into that category may suffer from cerebral palsy or Down syndrome or spina bifida or have a brain injury. So what I would hate to see happen then is, for example, you have a foster family who's taken on, the responsibility of serving, I'll wait for Jim.
I don't even know where this is coming from. Put it in the
Do you want
water.
to put in a glass of water or something?
Yeah. I don't have any alarms. This watch is smarter than I am. I'll take it out of there and you can continue. Anyone know?
So back to my question. So if you have a foster family, and let's say they are going to foster some children with disabilities that may fall under, one of these developmental disabilities, would they then be required to go through all the hoops that are put into this ordinance?
A foster family?
Because on the definition, it says, shall mean a building owned, leased, occupied by developmentally disabled or behaviorally disabled persons for purpose of establishing a personal residence. So while maybe not everybody in that home may be developmentally disabled, if some are, then I think that you're putting an undue burden on people who are just trying to foster some kids that need some extra help.
Well, that's an excellent question. What do you think?
Well, I think that this clearly meets the definition that's put into this ordinance.
It's the same definition that's in state code. So what would be the extra hoops that these folks would have to run into?
Well, it's all down here.
No, I understand.
Spelled out, but there's where you have to register with the finance director. So trying to find that section. I'm sorry, I'm looking past it, but okay.
It's 132605.
No, what I'm referring to is 132603, registration required. A complete registration form shall be submitted to the office of the finance director on a form established for such purpose. I don't like that we don't know what's on that form, and we're already going to put a burden on people, and we don't even know what the form is going to say.
Mm-hmm.
So that's a requirement, that you're requiring somebody to come down and fill that out when maybe they just have a few children that have cerebral palsy. I mean,
So under your under your interpretation, then the city should take action to do something about the limitation of the permitted use for group residential facilities that is set in state code.
well,
Because it has the unintended consequence of preempting those residences from our zoning ordinances as they stand anyway, and because it has the unintended consequence of doing that, then maybe the state statute should be invalidated.
no. I think that, first of all, I don't believe, in my understanding, and Ms. Ford brought it up, that this particular ordinance is in violation of the Fair Housing Act and also the American with Disabilities Act. May not be the intention. I think really what the intention of this is some way to control where people that have substance use disorder reside,
Mm-hmm.
but that's not what this says.
Well, okay. Like I said, when the ordinance is drafted, The ordinance simply adopts the definition for setting this out in state code, that is set out in state code, so that everyone knows specifically what it is that is being discussed. As far as dealing with the Fair Housing Act and so forth, I'm curious to know as to what ways that it would be violative of the Fair Housing Act.
Well, perhaps maybe you should read the reading that was of the judgment that happened in Petal, Mississippi, that was referred to.
But it's a different, okay. I mean, yeah, it's a different set of facts, but that's fine. And I'm fine. I'm not trying to be combative. I'm actually trying to massage this because I would like some guidance in how it is that we can address the issue that we have in the city.
That's question number one, and I'll move on since I don't think we probably have an answer to that.
I don't think I have an answer that,
Okay.
I don't think I have an answer that you would like to that, no.
Well, it's not an answer that I would like. I would just like to have the answer, but
I don't mean like as in, well, it doesn't matter.
okay.
Never mind.
Number two, so when you, the mayor referred to facilities, there are two different types of facilities. And I think we're kind of glossing over the first type, which everybody's familiar. Last year we went through the moratorium of the sober living home down on 10th Street, the Oxford House. That is a different situation than a facility similar to, probably what everybody's familiar with here in town is like the fellowship home that, I don't know who runs that now, but for years and years and years, Patrice Puller did. My understanding, and we went through this before, you cannot zone people who are just wanting to live together in a residence, share expenses, all that stuff. You cannot tell people where they can live. Now, a fellowship home type situation is going to be a little bit different, and they certainly have certification from the state, and they get money and from DHHR and all of that stuff. That's a little bit different, but there are two different types of sober living homes. Am I correct?
Oh, I think so, yes.
Okay, because that part was really glossed over, and I think that that's well-established law, that you cannot discriminate against people who just want to live together.
Yes, I would agree with that. You cannot discriminate against people who want to live together. I agree with that.
So
You can regulate to some degree as long as that regulation is not involved in some type of protected class. We have statutes that prevent boarding, that allow for prevention. Statutes that allow or prevent boarding houses and so forth in what are commonly referred to as single-family dwelling or single-family zoned areas and so forth. You are correct, but I don't think you can make any discrimination based on something that would otherwise make a person be a protected class. And that's what I want you guys to think about whenever you're thinking about the ordinance. Is a lot of the stigma that we've had that seems to be attached to this is dealing with people that have substance abuse disorder. But also you have to understand that any action that you take is also could, through the law of unintended consequences, affect people that have other, and I'll try to get this right, other persons with disabilities that you may be affecting. And so when you look at all of these, you need to look at them through that lens and maybe take some of the stigma away. But to go back to your original question, part of this is forming these a business. These are things that are contemplating essentially businesses that are coming in, purchasing property, and the city is just asking for certificates of occupancy. I think the question or the scenario that you've put forth doesn't apply because a family that is bringing in foster children is not running a business. They are fostering children, whether they have some issue or not.
Can you show me in this ordinance where it says the definition is a business? Because that's not what it says.
I think you can infer it from how it's through the reading of the rest of the ordinance, requiring registration, zoning confirmation, certificates of occupancy. Those are things that are not typically associated with a residential neighbor or a residence that is located by itself in an R1 neighborhood.
We can infer a lot of things, but that's not what it says.
You can put that with my watch.
So, and many of the things that are in here already apply to zoning. So, I mean, if you have a problem with the definition, I could certainly massage the definition so as to make it clear that the intent isn't to affect individuals who are living outside of these, I guess we'll call them group homes scenarios. I mean, if it makes it clear, I'm just here to try to help council with its objective.
I think this whole ordinance is very unclear, and I don't think that it's going to meet any test if it's challenged legally, and I most definitely think it will be immediately challenged.
Okay.
As soon as somebody wants to come in to Vienna and either purchase or lease a home, and they fall under this criteria, you know, and they're prevented from it, or they have to follow these regulations, then it's going to get challenged, and I feel certain that we will lose.
Okay. I mean, any litigation that's zoning ordinances have been challenged for as long as zoning ordinances have existed. I can tell you that I can't tell you how a court's going to rule on anything, and I can tell you that every zoning ordinance at one time in one variation or one form throughout the history of municipalities in this country have been challenged one way or another. Sometimes they've been challenged successfully, and other times not. So, I mean, just to say that as soon as an ordinance passes, there's going to be litigation. I mean, my advice to you is yes, that's a possibility. Anytime we pass any ordinance that involves zoning, there's the possibility of litigation.
Of course, everything, there's a possibility of litigation. I think we all understand that. But I'm very disappointed in this language and what it says. I find it very offensive, actually. And I think in Vienna, we have better values than that. And so I will not support this.
I'd like to speak on this now. You know, this is not about having an agenda which, you know, making judgments that this is illegal, it violates this, it violates that. I think the word that Russ used that most exemplifies what this ordinance is about is a balance. We have a community of citizens who we serve, and when we come into a situation with an ordinance where we're trying to balance the interests of our citizens with the rights of all people, then we do need to rely, and Chris sent me an email and asked me kind of what I thought about this, and I said we talked about it a lot with the moratorium, but at some point, if we think this reflects the will of our citizens that have elected us, then we have to rely on and defer to the advice of our council, and certainly it can be challenged. And this is drafted in a way, and Kim's interpretations are just that, interpretations, her opinion as to how the law applies, whether federal law preempts. And the other thing I told Chris is, you know, my job here as a council person is not to give legal advice to this council. This guy is. Thanks. And yeah, and I'm happy about it. Yeah, but, you know, so, you know, there are problems with the percentages of this problem that our communities are dealing with that we have to struggle with, and we have to try to reach resolutions that we think are consistent with the values of our community, with our responsibilities as elected officials. And if first of all, if our council is telling us that this is a way forward, it is balanced and protects the right both of protected people and of our citizens, that I'm willing to rely on that advice and say that, you know, this is a balanced effort to protect all interests involved, not discriminating against anyone, not with agendas against anyone, all right, or agendas for anyone, all right? And so that's my position on this. I think that this does appear, until challenged and overturned, to be a balanced approach within the constraints of superior law, state and federal law, And if council as a body determines that this does in fact is a reasonable approach within the law, that it's, you know, that it's worthy of our support, and to see what happens, because it's not a crystal clear picture, and somebody can make pronouncements, but that don't make it so until the judge drops the hammer all the way to the final arbiter of the Supreme Court. Nobody knows for sure. And so that's, I think, what the approach must be here.
Mr. Hazinger?
I'd just like to speak in favor of it. I think the word balanced has been used several times, and I think it's the ordinance is well balanced. Will it be sued? There's an old saying, you can sue a ham sandwich. So. But I think it's the right approach for our situation, and I wholeheartedly support it.
Anyone else?
Yeah, can I ask a couple of questions?
Sure.
Hopefully I can answer them.
I guess, so one of my main questions is, without this ordinance in place, can we refer to the building code and zoning that we already have to, I guess, balance this situation? Can we require in our building code, can we require certificates of occupancy and, you know, that all of those things are up to code without this ordinance?
I think that some of the safety things you can, that can be addressed through code. The problem is, so yes, to answer your question, yes, some of the things I think are to some degree addressed with code. The problem is your code, R1s, R2s, R4s are different. What is it? R1, R2, R3, and R4 are the different residential zoning categories for the structures that we have. In each of those, and we regulate people all the time. Every house in Vienna is regulated by the zoning ordinance. You're very popular tonight. Every residence is regulated to some degree. If you live in an R1 neighborhood and you're not exempted by this, your house has to conform to the regulations that are there. If you live in an R2, same thing, R3, right? I guess what I'm trying to point out in this, so yes, there is. If I want you to look at 06 to see what actually the meat of a lot of these things are. 06 just talks about the separation, says that the residences can't be should be no less than 1,500 feet from each other. So, and the intent of that, I think, is to prohibit several of these business type facilities from operating in what was traditionally an R1 type neighborhood from being cloistered together. Occupancy, that's to some degree a safety issue. You have a 4-bedroom house and you have a residence, or you have one of these places that come in to run a business, and one of the businesses is to provide services to people that are developmentally disabled. There's no regulation that would prevent them from bringing, you have a 4-bedroom house, let's put 4 people per bedroom. We have 16 people in a house that was really designed to have 4 or 5 or 6, right? The paragraph 3 says, don't have a sign in a residential neighborhood that says that this is this house or that house. You have to remain in compliance with building and fire safety regulations. If you are the type of facility that has to have a license, you have to have a license. The parking thing is a pragmatic issue. That's addressed in our, make sure I have that right. But we have parking restrictions on how many cars can be parked. If you have an apartment building, you have to have so many lots and spaces available for each of the tenants that are in there. Tenancy, it just says you can't have people there that are a threat to the health, safety, or others. Exclusive use, you can't do your administrative activities in the structure. Most of the places that you can't run a business out of a residential neighborhood. You have to report any deaths, and there just has to be a person that can be a contact to deal with this. So some of these things would be covered by our regular ordinances, but because of the way the code is set out, we can't have a lot of these regulations, or some of these regulations that apply to these facilities. I hope that answers your question. That's about as good as I can do.
Are you finished?
Are you done, Chris?
Well,
He's thinking.
yeah, I guess Kim brought up a point that I guess I'm a little bit confused on in the idea of what a business is versus establishing a personal residence. I know that comes from the state, and because of that personal residence, I don't know how we can say that this is for or against businesses. I mean,
And
it doesn't seem very clear to me in that.
And I think this draft of the ordinances is just trying to attempt to use a common definition. The common definition is the one that was given to us by the state. If the city wants to change that definition to specifically say business, to clarify if council's concerned that this could some way impact families or individuals, as Ms. Williams pointed out, you can amend your ordinance, or you can amend this draft of it. I'm not married to it. I took the one that Parkersburg had in hopes that there would be at least some uniformity in expectations in neighborhoods.
Aren't there some inferences there that you mentioned a while ago that they have to jump through some hoops that a business has to when they start, and to move into a house, you don't have to do those things.
That's correct.
Typically, if you have a family living in a single-family residence, the people that live there don't pay rent. All right? I mean, it's mom and dad, 2 kids, and they don't charge the kids rent typically. All right?
I do.
There you go. Okay? But the reality of this is the people that come to these homes, they're paying whoever the landlord is or the owner of this for every person that's in that home. And that's where the business side of it comes to, is they're collecting rent from any number of people. All right? And so, I mean, the one house that was referred to earlier, the Oxford house, I don't remember exactly how many it was, but it was 9 or 10 people in a home that was designed, 9 or 10 strangers that were in a house that was designed as a 3-bedroom home. All right. And, each one of those people were paying $800, $700, whatever the rate is that you get for that. And so, I mean, that's a very profitable business right there.
Well, is that not the same as being a landlord and renting out an apartment building?
If you're in an area that is zoned for, like a townhouse or a set of apartments, but not a single family residence.
Yeah, I think that's the dichotomy here, is that because of the protected nature of the people we're trying to help, that the tension is between, can they escape our regular zoning laws that apply to everybody else, with example for parking? And I think that is the distinction. Like, if I want to live together with 3 other guys like I did in college, right? Yeah. We have to comply with those zoning laws, and we're each paying our own rent. But when these, is this, and this is a question for us, because I've not researched this like he has. So a tenet of this is a business placing these residences for purpose of their profit and the benefit of the residents. But, and so that's kind of where I draw the line and say, how do you justify that they can come in, place 10 residents, and however that money is funded to pay for them, whether it's state, federal funds, going to that business entity, and they're allowed to come into our communities and do things nobody else is allowed to do, as a private citizen. That's kind of where, like I said, it comes back to the balance. And I think this is a conflict that has to be resolved now, and maybe beyond this council, right, to the state, because when we did this moratorium, we had an issue with the way the state statute was drafted, and I don't think it's been resolved yet.
Yeah. So,
and somebody has to have the courage.
Yeah, I guess 2 quick kind of questions on that. That kind of leads back to my first question: is if we already have these zoning laws in place, can we not just enforce those as part of the residential zoning to say, you
We
can't?
have them in place. Some of them don't apply to these types of facilities because of the state statute. So if I live in an R1 district, which is single-family housing, or I live in an R2 district, which is a mixed single-family, but I think it's not more than, two, let's just call it, what's the word I'm looking for? When you have two apartments split into a house, duplex, thank you.
Yeah.
So you live in an R2 or you live in an R3 where you can have apartments, right? So the intent of the zoning is you have neighborhoods that are single-family houses, and your infrastructure is designed for that. You have neighborhoods that have a mix of single-family duplexes, and your infrastructure is designed for that. And the same, you have your apartment areas, and your infrastructure is designed for that. And it's not just infrastructure, but just things in general. Well, the problem is you can have the same number of people or occupants of a structure that, would normally be in an R3 because, they are in an apartment house. You convert a house, a 3-bedroom, 4-bedroom house into a house that can now have 10 people. So and I'm not saying that all of these people do. I'm trying to do what Ms. Williams does is use an example to illustrate a point. But so you essentially sublet or subdivide, or however you want to call it, a 4-bedroom house. You put 4 bunk beds in each room. You've got a house in a neighborhood that was designed for 5 people or contemplated 5 people with parking and so forth, that now you have 16 people in it. And you can say, well, a lot of these people don't drive. That's fair. And that's fair. They don't. There's a lot of folks that are in these types of places, in these facilities, may not, but they may. So what you've done is you've taken a property owner in a single-family R1 house or zoned area. They have this set of rules to live under. You've allowed a facility that's operating a business to have the house right next door to them and occupy it in a different way. And that's the problem with all of this is I don't think there's anybody in this room that wants to keep people who have any type of issue from getting the care they need or getting to choose where they live. I think part of this is just to try to figure out a way so that everybody can live under at least some semblance of the same sense of rules, taking into consideration the other issues. So that's what I'm talking about, is a house with 4 bedrooms being cut up to let 16 people live.
Okay. I guess I'm not super comfortable with, how the ordinance is kind of not necessarily laying that out very clearly for me. But then I guess my other question is, as far as the moratorium that we kind of have in place until the end of this month, do we know if that has been effective in any way or challenged in any way, or has...
I can tell you the moratorium hasn't been challenged in court here in Vienna.
Okay.
I can't say, I don't believe it's been challenged in Parkersburg. That doesn't mean that just because it hasn't been taken to court doesn't mean it hasn't been ignored. It doesn't mean it's been successful. I don't have any data that. The only thing I can tell you is I've not had to go to court to defend it.
Okay.
All right.
Are we done?
No. Russ, this is being presented as a first reading of the ordinance, correct?
Yes.
I don't know how the vote would go if it was taken, but there is a possibility that, even with dealing with it on first reading, that, perhaps if there was some language or some more information that came forth before the second reading, that the proposed ordinance can be amended.
Yes. As long as the amendments aren't material, and I think as long as the amendments aren't material, and I can't fathom too many changes that you would make other than to clarify that would be material. And even if they were material, you just have a third reading of the ordinance.
So I have another question, kind of spinning off what Chris was referring
Excuse
to.
me, Ken. Roger, are you finished?
Yes, thank you.
I apologize.
No,
I thought you were
I'm
finished.
finished, thank you.
It's nice to have you back, Mr.
Thanks.
Bibby. So I just want to clarify something. The statement that was made about the Oxford House. I was able to visit with them last year during the time that we were contemplating the moratorium, which did of course pass. And I spent quite a bit of time down there, about 3 hours, toward the home. I looked at everything. They were very open and welcoming. But that is not a business, okay? And it's a nonprofit. They do not charge this exorbitant rent that the mayor just mentioned. They don't. They charge a rent, whatever the rent is of the house, and then, they divide it up by how many people live there and other household expenses, utilities, groceries, that kind of thing. They put a little bit of seed money back in order to do, things within their organization. I think it's totally false to act as if it's some for-profit business. It's not. It's to support people who have substance use disorder, to support their sobriety. And I think that we all can agree that we support people being sober. As far as, houses, when you talk about zoning, and, you can have a large family. You can have a family of, maybe there's 8 kids in this family. You have 10 people, and they live in a little, 3-bedroom house. That happens all the time. That's the same thing. What you're trying to do with this ordinance is say it's just going to apply to businesses, but that's not what this ordinance says at all. Okay, and I think that whatever the intention is, and I think the intention really is to try to manage in some fashion sober living homes, okay? But whether you agree with that or not, the unintended consequences is that we are going to be harming people that we didn't intend to harm. So I think that this probably needs more thought, and so I would like to make a motion to table this ordinance.
Motion's been made to table this ordinance.
I would like to second that. I just feel like there's way too much in this that I have too many questions on, so I'll second.
Okay, so let me say it's been moved and seconded that we table this, and I guess I'm going to comment on this. It's a situation where two things. There has to be rules somewhere, and you hope that your zoning would take care of the bulk of these. But there are situations that occur because there's some streets in Vienna that are very narrow, and parking is at a premium. And so, having all of these extra people to block the streets so they're almost impassable is one of the concerns that I get all the time. And the second thing is when a mother of 4 calls me on the phone and says that because of this house that was being used beside her, that she was terrified and she sleeps with a baseball bat in her bed because her husband works nights, and that the first week that this house was opened, that there was an overdose, and the police had to be called to that very house, and that they find needles in the yard. That is the kind of thing that concerns me about the sanctity and the balance of our neighborhoods, because we all want to be safe when we go to bed at night, and we want to have the hope that the values that are in our homes will be there, so that at some point, if we want to sell our homes, that our neighborhoods are welcoming to new people that come in. And so I would speak against tabling this. I believe the point was adequately addressed by Mr. Bibby, that if this is first reading, and if there are things that need to be clarified or tweaked, we certainly have the option to do that. But I would like to see this passed on first reading so that we at least move forward with this issue. Any further discussion?
I'd just say, we got to make a decision. I mean, the ordinance, whether you agree with it or you don't, it clearly states it's been well-researched and drafted by our city attorney, and he's expressed his opinions that this is the best effort that we can make. We have time in between the first and second readings to add additional input. You'll have the opportunity at the second reading to make any amendments that you think are appropriate, and if they're adopted, they'll go forward. So let's make a decision. I would oppose tabling it.
All right. Then I will call for the question that the motion to table has been moved and seconded. All those in favor of tabling this issue, please signify by raising your right hand. All those opposed, same sign. All right, tabling fails 2-5. So we go back to the original motion and second. This is an ordinance regulating group residential homes. Be it ordained by the Common Council of the City of Vienna that Article 1326 of the codified ordinances of the city is hereby enacted, enacting regulations for group residential homes. All those in favor of the ordinance on first reading, please signify by raising your right hand. All those opposed? Motion carries 4-3 on first reading. It will be back on the agenda for the meeting on the 23rd.
And Russ, when are we able to ask for the amendments? Can we do that now then?
You can send, if you have proposed amendments, send them to me. I'll get them I can try to put them in a form that makes it easy for you all to deal with later. I certainly wouldn't mind having some suggestions on this. It is what it is. I mean, but yeah. And then when would you actually make the amendments the next time it's set on the agenda? But if you want to prepare amendments ahead of time, you want to send them to me, I'll format them. At least it gives me an opportunity to look at what it is that you're wanting to do or try to accomplish.
Who decides if the amendments are germane?
Well, it's just like every other amendment procedure. What I'm not going to do is write a re-amended ordinance. We'll have the ordinance that is before council, and if you have amendments, we can bring forth those amendments, and you would propose the amendment, ask for it to be moved and seconded, and then vote on it accordingly, and then it's my job to figure out how to get all that to work.
All right. So we move on then. Item number 2 this evening on our agenda is an ordinance amending Article 1371 of the Vienna Municipal Code and regulating the location and placement of residential substance abuse treatment facilities. This is an ordinance amending Article 1371 of the Vienna Municipal Code 1371 and regulating the location and placement of residential substance abuse treatment facilities. Be it ordained by the Common Council of the City of Vienna that 1371.03 residential substance abuse treatment facilities. A residential substance abuse treatment facility means a live-in inpatient facility or center providing substance abuse therapy or treatment to individuals. It does not include group residential homes as defined in West Virginia Code 27-17-2 or a residential care community as defined in West Virginia Code 16-5N-2K. 83A, substance means both alcohol and controlled substances or drugs. No residential substance abuse treatment facility shall be located within any of the following areas. Within 250 feet as so measured from each property line of a residential district. Within 500 feet as so measured of a public or parochial school. Within 100 feet as so measured of any existing residential substance abuse treatment facility. I'll entertain a motion on first reading for the ordinance amending Article 1371.
So moved.
Second.
It's been moved and seconded that we approve an ordinance amending Article 1371. Is there any further discussion?
I have a question. This is for Russ, actually my question. Sure. When I start to think about properties in Vienna that would be large enough to do this thing, and we do not have any of these currently in Vienna, to my understanding. Is that correct?
Right now, I can't think of any building that is open that could be used this, but right now, I don't believe so.
Okay, and I know Ms. Ford had said there are 24% of these facilities in Wood County, correct? Well, I think that Wood County has, we probably have enough of these facilities in Wood County at this point in time, but OVU, that is as everybody knows, it's going through bankruptcy and that will be sold at some point in time. That is in an educational zone.
Yes, that is, we created an educational zone a handful of years ago. Yeah.
Okay, so if this did not pass, I mean, are we protected in that educational zone from that being converted into a residential treatment facility?
You know, I'm embarrassed to say I need to go back and look because I can't remember off the top of my head how all of the, give me 1 second.
Okay.
Give me 2. All right. Sorry, I haven't looked at that in a while. Well, I suppose if you were creative enough with how you wanted to establish your business, I think there's a possibility that, yes, it could. The educational zone, I think the educational zoning ordinance never contemplated that. The definitions talk about colleges, schools, kindergartens, and so forth. But I suppose you could get, if you got yourself qualified as a school of some sort, offered some type of educational service that satisfied our ordinance, you could also, you know, put a treatment facility in.
Wouldn't that be a stretch?
Well, I think it'd be a stretch, but people are very creative.
It probably could be said for a lot of things with zoning, right?
Yeah, it can be.
Is there any further discussion? Hearing none, then I'll call for the question. All those in favor of the ordinance amending Article 1371, please signify by raising your right hand. All those opposed, motion carries on first reading. It will also be back on the agenda on the 23rd. Ladies and gentlemen, it's been almost an hour and a half since we started. Before we get into our remaining items, I'm going to ask for a 5-minute break. We'll return back at 7:30.
I don't